Now, you work with a lot of trial attorneys, and one thing I've noticed that trial attorneys hate is appellate attorneys like us telling them all the issues they need to put into the record, even though it's so patently obvious to the trial attorney that the trial court is going to reject all these arguments and objections and just get annoyed. After all, the trial attorney still wants to persuade the trial court and doesn't need us appellate attorneys throwing spaghetti all over the place, hoping something will stick on appeal. So how do you go about responding to these kinds of concerns on the part of trial attorneys?
Well, I'm generally pretty blunt and say, look, you are going to be far better off at the end of this case having preserved an issue than having waived it, because there's no worse feeling for an appellate attorney to get a new case in hand and see a wonderful issue and find out that there was no objection or somehow the issue was waived. And there must be no worse feeling to a trial attorney to be told that because I'm not hired by the trial attorney, I'm hired by the client, which means I have to inform the client that but for this procedural mistake, they may have preserved a winnable claim. And we know where that goes. So it's uncomfortable, but the loyalty of the appellate attorney is always to the client, not to the trial attorney who refers the case. And I'm blunt about that too with the trial attorney. You know, if you don't preserve the issue, you are putting a claim at risk for yourself as well.